Hello everyone, welcome to the channel. If you are a law student preparing for Judiciary, CLAT or any competitive exam, then this channel is for you. Today we are going to understand one of the most important topics in contract law. What is a valid contract and its essential elements? Don't worry, if you are studying this for the first time, by the end of this video, you will clearly understand all 10 essentials of a valid contract with simple examples. So let's begin. What is a contract? Before learning the essentials, let's first understand what a contract actually means. According to Section 2 Clause H of the Indian Contract Act 1872, a contract is an agreement enforceable by law. Now let's simplify this. Whenever one person makes an offer and another person accepts it, an agreement is formed. But every agreement does not become a contract. An agreement becomes a contract only when the law recognizes and enforces it. The easiest formula to remember is offer when accepted will become agreement, and agreement when enforceable legally becomes contract. Keep this formula in mind because it is the foundation of contract law. The first essential element is a lawful offer and acceptance. Every contract begins with an offer. One person promises something and the other person accepts it without changing its terms. For example, Rahul offers to sell his laptop to Priya for 40,000 rupees. Priya agrees to buy it for the same amount. Since the offer is accepted exactly as made, an agreement is created. If Priya changes the price or conditions, then it becomes a counter offer instead of acceptance. The second essential is the intention to create legal relations. The parties must genuinely intend to create legal obligations. Not every promise becomes a contract. For example, if two friends promise to watch a movie together, that is only a social promise. If one friend does not come, the other cannot file a legal case because there was no intention to create legal relations. Business agreements usually have legal intention, while social and family promises generally do not. The third essential is competent parties. Under Section 11, every person entering into a contract must be legally capable. That means the person should be a major, should be of sound mind, and should not be disqualified by law. For example, if a 10-year-old child signs an agreement to buy a car, that agreement is generally not enforceable because a minor is not competent to contract. The fourth essential is pre-consent. Both parties must agree voluntarily. Their consent should not be obtained by force, fraud, undue influence, mispresentation, or mistake. Imagine someone sign an agreement because they were threatened. Even though they signed it, their consent was not free. Therefore, such a contract may not be valid. Always remember, consent should come from free will. The fifth essential is lawful consideration. Consideration simply means something of value exchanged between the parties. It may be money, goods, services, or even a promise. A simple rule is no consideration, generally no contract. For example, A sells a phone and B pays money. Here, the phone and the money are both consideration. The sixth essential is a lawful object. The purpose of the agreement must be legal. If the object itself is illegal, the contract becomes void. For example, if two people agree to commit a crime in exchange for money, that agreement can never be a valid contract. The law never protects illegal agreements. The seventh essential is that the agreement should not be expressly declared void by law. Some agreements are specifically declared void under the Indian Contract Act. Such agreements cannot be enforced no matter what the parties want. Always remember, a valid agreement can become a contract. A void agreement never become a valid contract. The eighth essential is certainty. The term of the contract must be clear and definite. If the agreement is vague or confusing, it cannot be enforced. For example, if someone says, "I'll pay you a good amount someday," this statement is uncertain because nobody knows the exact amount or date. Therefore, certainty is essential. The ninth essential is possibility of performance. The contract must be capable of being performed. The law does not recognize impossible promises. For example, if someone promises to bring the moon to earth, it is impossible. Since the promise cannot be performed, it cannot become a valid contract. The 10th essential is compliance with legal formalities. Some contracts must be in writing, some requires registration, some need stamping according to law. If the required legal formalities are not completed, the contract may not be enforceable. So always follow the legal requirements wherever applicable. Now let's look at an important case, Balfour versus Balfour. In this case, the court held that agreements between husband and wife made in a domestic setting generally do not create legal obligation. The reason is simple. There was no intention to create legal relations. This case clearly explains why legal intention is an important element of every valid contract. Let's quickly revise all 10 essentials. Number 1, offer and acceptance. Number 2, intention to create legal relations. Number 3, competent parties. Number 4, free consent. Number 5, lawful consideration. Number 6, lawful object. Number 7, not expressively void. Number 8, certainty. Number 9, possibility of performance. Number 10, legal formalities. So today we learned what a contract is and the 10 essential elements that make a contract legally valid. The key formula to remember is offer plus acceptance is agreement. Agreement plus legal enforceability is contract. I hope this video helped you understand the topic in a simple and easy way. If you found this video useful, please like the video, subscribe to the channel and share it with your friends. Also let me know in the comments which topic of contract law you had like me to explain next. Thank you for watching and I'll see you in the next video.